My name is Kerry Rees. I'm a partner at HGF and I'm based in London. Before I start the presentation about using IP to attract investment, I thought that I would give just a short introduction to HGF and what we do. So HGF is an IP law firm. We are based in the UK and across mainland Europe. I think we're one of the largest IP firms in Europe with 21 offices in the UK and others in those countries that are listed there. We have 63 partners, I think, now, and we have sectors covering life sciences, chemistry, engineering, electronics, and trademarks. We also have a dedicated law team specializing in IP transactions and IP litigators. We have specialist IP groups, which I thought might be interesting for this conference, which relates to food technology. My background is in biotechnology and biochemistry, and I'm a patent attorney with a particular interest in food tech and the alt protein market. So some people like to know, that's just showing the kinds of work that we do. So essentially we cover all IP fields and all IP matters, whether it's from drafting and advisory filing services through to appeals and oppositions, due diligence, freedom to operate. Some people like to know how we stand in the IP rankings, and this slide just gives a brief overview of some of the legal awards we've recently won and some of the great work that my colleagues carry out. So let's get into the presentation today. So how do we use IP to attract investment? So I know the conference is focused on the alt protein market, but actually developing an IP strategy ought to be aligned to the business plan. And so that's applicable to all tech companies, I think. So I hope that whatever field you're in, the following will be relevant. So what a company's aims are in terms of its business plan, and how does this align with what private equity investors want to achieve? So let's start from the point of view of the investors. So investors that invest in tech-driven companies understand really these days that IP is a key asset, and that underpins private equity funding over all series. So wherever you are in your funding rounds, investors will conduct IP due diligence to check that the IP position, what risks the IP position may pose to the investment. So any problems with the IP strategy can lead to revaluation of the company. It can affect whether an investment is made or not, and actually the share that investors will want from a particular investment. So there's room for negotiation if the IP strategy is wrong in some way. So it's really important that a company seeking investment can demonstrate that it has assessed its IP risk and how it will manage any risks that are identified. But also, I think the company will need to convince the investor that the investment is safe and it will grow to the point of exit, whatever exit that may be. So really what we're talking about here is how does a company's IP strategy fit within its business plan? If a company doesn't have a business plan, then it's very difficult to draft a proper IP strategy or come up with one that is going to affect, be in line with what a company wants to achieve and whether the investor will be confident in investing in that company. So a company should have the business plan in place, and in order to develop an IP strategy that fits within it, whilst what on this slide is not an exhaustive list of what should be in a business plan, I'm sure you all know to do that. Really, when we think about IP, we have to think about what products or services you're proposing to offer, where you're offering them, or where you're making your products, and where you're going to sell your product, who your competitors are, and how you are going to exploit your IP, and indeed how you're going to enforce it if ever the need should arise. So those are the kind of things that we need to think about in drafting an IP strategy that fits with your business plan. And really, I think there are four sections here. IP capture, so how you interact with your R&D and product development, and how you go about filing your IP, so your patents and your trademarks, and also what IP you already have and whether that's fit for purpose. Then the second section is how you're going to use your IP for a commercial advantage. So how you're going to make money from it, essentially. And third, how you are going to monitor any third-party IP rights. That's important just to assess whether you're infringing a third party, or indeed whether or not a third party might be infringing your IP. And then fourth, how are you going to use that information? How are you going to enforce your IP, or how are you going to revoke someone else's? So let's start at the first point, which is the IP capture. And what we're considering here is what IP do you already have, and if it's fit for purpose, and then how are you going to capture any IP that's generated from your R&D. So this is a really complicated process, and there isn't one size fits all approach. It really comes down to what IP strategy is needed in order to fulfill your business plan. But things to consider are, certainly in respect of existing IP, is whether the IP you think you have actually exists, and do you own it? And there have been several companies I've worked with that think they have some IP, some patent that's granted, or a trademark that covers their goods and services when they don't, or one does exist, but it's owned by somebody else. So, and also it's often, well, not often, but sometimes the case that IP actually, does the IP cover the product or service you were selling it, or does it not? And is the scope of protection, say for a patent, covering your business down the line and any developments to the products in years to come? So really the process of review of your IP is ongoing and needs to be periodical. Acquiring new IP really needs to be driven by a general understanding through the company, from the board right down through to R&D directors and IP managers. So there's little point really in R&D making some wonderful new development, but it doesn't fit with the objectives of the business, and that's because the board hasn't effectively communicated with the R&D staff and IP managers about what kind of IP they should be pursuing. It can be expensive to obtain patents and trademarks. So for smaller startup companies or SMEs, small businesses need to use their patent budget spend wisely. So really having an IP strategy aligned with a business plan, you can selectively file in regions that are important to fulfill your business plan. And really not needing to file everywhere and file for every particular development you make. There's also some things that you can do which will make your life easier in terms of liaising with your patent attorneys and investors. So things like invention disclosure forms and having agreements and assignments and status reports in place are really important, because often due diligence and IP investment is a fast-moving process, and you need to be able to provide this information quickly. And your costs will be much reduced when liaising with external advisors if you can have these forms ready to go when needed. You should also look at things like employment contracts and research agreements to ensure that your IP is owned by the company, and whether there are confidentiality provisions in place in the event that somebody leaves your company. And also you need to have a plan about what IP is appropriate. So sometimes filing a patent application, for example, is not appropriate because maybe the technology you developed doesn't have the proper data yet in order to support a patent to grant. So one thing is certain: once you file your patent application, unless you withdraw it in the first year, you're going to be publishing that information at 18 months. But there's no guarantee that the patent is going to be granted. So you really need to think about whether the quality of your data and the developments you've made are appropriate to file, and indeed whether it's appropriate just to keep the invention secret. One thing is certain, though, is that if you disclose an invention without having your IP in place, then that can seriously prejudice the chances of getting a patent granted. And so there's a balance really about keeping a patent secret and filing a patent application to attract investment. Some people like to think of your patent as maybe your insurance policy. So it's worth the investment for maintaining market share. And when things go wrong, you ought to be able to rely on it. The next stage is how are you going to monetize your IP? So how are you going to make money from it? Or maybe not money, that's a bit crass, so maybe a commercial advantage. So the main monopoly right granted by patents and trademark is to keep competitors off the market. But that doesn't mean that your IP, you have some granted IP means that you're going to be able to work your IP as well. You might need to in-license a bit more on that later when we talk about third-party IP. Another option for generating revenue is to sell your IP. So maybe your business is just in it, you make developments, you file your IP, and then you sell it on, or spin out companies based on some IP that you generated. More common is licensing your IP. So granting third parties a license to use the invention. That's a complicated area in itself, that you need to determine the terms of the license, whether it's a solo exclusive license, for example, the royalty rates that you're going to charge, and also how long you're going to grant that license for, and have provisions such as if a licensee isn't performing as well as it said it would or you thought it would, how can you revoke the license and maybe start granting a license to somebody else. Third-party IP there are two aspects to this. So we're talking about what is your risk to infringement, so infringing other people's patents, but also what do you do, or how do you assess whether somebody is infringing you? So having your own IP, as I mentioned previously, doesn't necessarily mean you can work your invention or sell your products freely. You might need to in-license other IP in order to do that. So you might want to consider conducting a freedom to operate, an FTO exercise it's called. So you're assessing your IP infringement risk of third parties' IP. So there are sensitivities though as to when an FTO is conducted when you're going through due diligence processes and trying to raise investment. And you should really only be doing an FTO when you have a product that you know you're selling or process you're conducting, because if you change that, then obviously the FTO opinion is going to change as well. And you also don't want to be putting a load of risk on a table, identifying things that are potentially going to block you when you're in the middle of some due diligence or seeking investment. That kind of thing needs to be done pretty early on, or at least you have a plan of how to get around any IP that you discover that's problematic. And you can find out lots of information about third-party IP by looking at various IP databases, things like Espasnet and PatentScope, and you can identify potential licensees from that, look at competitors' developments, and place patent watches on tech areas, so see whether there's anything that you think you might be infringing as time goes on, or just keeping an eye on how things are developing in your competitors. With suppliers and joint developers, you need to check their IP and IP agreements as well, particularly if you're reliant on a particular supplier to provide goods or services in order to work your invention, and whether their IP that protects their business is valid or prone to be revoked. And there are also mechanisms where you can remove problematic third-party rights rather than litigating nationally. There's things like EPO oppositions, is quite a nifty route to revoking potentially patent applications European-wide in the 9 months post-grant period. And then coming to the end nearly, the fourth facet of an IP strategy and is how you, in your business plan, are going to account for in the event that you need to take action against a third party, or if you find yourself infringing somebody else's rights. What is your attitude to litigation, and are you willing to spend? There will be significant costs in litigating, for example, a patent infringement case, and think about realistically what are your competitors' attitudes and what are your attitudes, and are you likely to end up in court, or will you have some sort of licensing deal done? And I thought I'd mention some war stories just to round off about cases that I've worked on and companies that really had kind of a woeful IP strategy. And I talked about communication between R&D and employees, but some key tech wasn't protected by IP. And by the time that was published or made public disclosed to the public, the protection was already lost. So in that case, the investment wasn't obtained. and others where there was a UK SME that thought it had lots of patent applications, but none of them actually protected the product line and that was commercially relevant to the product that was sold, because the IP wasn't reviewed on an ongoing basis. So they were labouring under the misapprehension that they had some IP in place when really it was rather useless when it came to covering the product they were selling. And then it's not just all about patents. On trademarks fronts, there was a food company that needed to rebrand and change its product name because it hadn't had clearance of that trademark in other jurisdictions outside the UK. So that's it from me. If there are any questions, then I'm around for the rest of the evening, so feel free to get in touch, or over the next couple of days, just email me, just there, kerryrees@hgf.com.